Brian Rubihayo. Most obliged. I'm most obliged, Your Worship. I'm most obliged. Your Worship, Brian Rubihayo for A1. Your Worship, mere introduction of a charge triable by the High Court has no implication on the application for bail in respect to other accused persons who are charged with offenses that are triable by this honorable court.
Triable and bailable. Triable and bailable.
The charge, which is only triable by the High Court, is in respect to one accused person. The rest of the counts are bailable and triable by this court. And my Lord, I'm relying on the authority of Foundation for Human Rights, Foundation for Human Rights Initiative versus Attorney General. Your Worship, this is a constitutional appeal. It's a decision. Foundation for Human Rights, for Human Rights Initiative versus Attorney General, which is a constitutional appeal number 3 of 2009. Your Worship, I undertake to furnish the court with hard copies immediately after this session. And I refer the court to look at pages 24 and 25 of the lead judgment. So, Your Worship, for purposes of the court, pages 24 and 25. Your Worship, just briefly, if I may read for the court. It is the effect that if a court has jurisdiction to try an offense for which an accused person is applying for bail, if the court has jurisdiction to try an offense which an accused person is applying for bail, it therefore follows that if an offense is triable by a magistrate's court, then Your Worship, it therefore follows that if an offense is triable by a magistrate's court, then such a court has powers to grant bail. Such court has powers to grant bail in respect of such an offense. And so, Your Worship, our submission is that except for one count, which is in respect to only one accused person, the rest of the offenses are triable by this court. We submit that this court is clothed with the jurisdiction to entertain the application for bail and also grant the accused persons bail. My Lord, in summary, is that if a court can try, then it can grant bail. And my Lord, you will look at the reasoning in that decision that we have furnished. So, Your Worship, my two colleagues will just add a few authorities and I so submit.
Counsel for F5. Your Worship, we totally associate ourselves with submissions of counsel in as far as their position is that the application for amendment by the prosecution at this stage and the prosecution's position that the accused's application for bail is overtaken by events or amount to abuse of court process. That position of counsel who have previously submitted, to fortify that position of counsel who have previously submitted, I wish to furnish this Honorable Court with an authority of the High Court. Male Mabirizi Chiwanuka versus Attorney General. It's one of the many he has filed, but this one, Your Worship, is miscellaneous application number 917 of 2021, MA number 917 of 2021. That is, Your Worship, I'm sorry, Male Mabirizi Chiwanuka. Male Mabirizi Chiwanuka versus Attorney General. It is miscellaneous application number 917 of 2021. 917, Your Worship, of 2021. Arising out of miscellaneous number 843. of 2021, itself arising out of miscellaneous cause number 287 of 2021. Where Justice Sekana defined abuse of court process to amount to where the court is used for improper purposes. Where the court is used for improper purposes as a means of vexation, and oppression. Or for ulterior purposes. Your Worship, in short, where court is being misused. Your Worship, Justice Sekana further defined it to include improper use of judicial process by a party, aimed at or targeting interference with the administration, aimed at from improper use of judicial process, aimed at or targeting on interference with the due administration, or interference with the due administration. Clearly, Your Honor, the present case is a classic example of an abuse of court process. The accused persons applied for bail. The state requested for time to respond. Time was given to it, and in a dramatic turn of events, in a bid to deny the accused person's right of the application of bail to be entertained, they have come up with a frivolous and vexatious application for amendment of the charge sheet. It's our considered opinion, Your Honor, in the prevailing circumstances, that this Honorable Court should be pleased to disallow that application and, as prayed by previous counsel for the accused, either compel them to respond to the application for bail, and if at all they are not ready, court should be pleased to proceed and grant, or make a decision rather, on our bail application, Your Honor. I undertake to furnish this Honorable Court with a copy of that decision, which clearly demonstrates what's going on this afternoon, Your Honor.
In conclusion, Your Honor, I fully associate myself with all the submissions that have been made in opposition of the application by the prosecution. It's an application made in bad faith, and a wrong law, and an abuse. And an abuse of the process of the court. Your Honor, on the 21st of June, 2024, the prosecution told this court that inquiries were complete. And indeed, they are ready to prefer charges to accused persons, which they did. If the inquiries were complete, and we have no reason to doubt that they were indeed complete, how come they couldn't see that the evidence they had on record revealed this new offense? The introduction of this new charge is a premeditated action designed to deny the accused persons their rights to apply for bail so as to get their freedoms as guaranteed in the Constitution. It's designed to deny the accused persons their right to apply for bail to get their freedoms as enshrined in the Constitution. And I want to point out an absurdity. The Director of Public Prosecutions, under the article which
120.
my land colleague read,
Yeah, 120 clause 5. It's 120. 120. Here. Here. Clause 5, this one.
is supposed to exercise his powers under this article, but must have regard to the public interest, the interest of the administration of justice, and the need to prevent abuse of legal process. Now, the custodian, the person supposed to safeguard observance of, I said Article 120,
Clause 5.
Clause 5
The Constitution.
of the Constitution. The overseer, the custodian of the law, because the DPP represents the entire state, to be the one now trying to cut corners at the expense of freedoms of citizens is a big absurdity. Your Honor, I want to suggest a way forward in these circumstances, because definitely this application cannot stand. Your Honor could dismiss or disallow this application, and we'll go ahead to entertain the application for bail. That's one option. To order the prosecution to withdraw this case. Go back and prepare themselves, and when they are ready, they take whatever step they want. They summon their chosen persons, and we shall be in court.
Adrian.
There is a third option, Your Honor. The third option could be to sever the charges.
The language was strong, eh? Fresh charges. The language was too strong.
Sever the charges so that those accused persons charged under law triable by this court, under laws, under offenses triable by this court, proceed with the application for bail, and bail is granted. And those on a mandatory charge, and I think it's only one accused person, be committed and wait to apply in the High Court. Lastly, I pray that the prosecution should be reprimanded for their clear gimmicks. Of holding the court at ransom and standing on the way between accused persons and their freedoms. Reprimanded for their gimmicks.
That's okay.
Of lying behind the law to deny the accused persons of their freedoms. I so pray.